With Justice Amy Coney Barrett confirmed, will Joe Biden pack the Supreme Court if he wins? Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today we're going to be talking about former Vice President Joe Biden and why does he refuse to answer the question on whether he's going to pack the Supreme Court if he gets elected. With Justice Amy Coney Barrett now confirmed and sworn in, Democrats are basically in a panic. They don't know what to do. Republicans have cemented a 6-3 constitutionalist majority with Republican-appointed justices now on the Supreme Court. And that can mean Democrats are in the wilderness for a generation or more as Republicans are able to perhaps get more of their agenda into law and be upheld as constitutional. And Democrats, perhaps some of their socialist plans are going to be shot down now because there's a conservative constitutionalist majority on the Supreme Court now. And I think that can make a big difference. That's what the fight is all about. And that's why Democrats, I believe, want to abolish the filibuster right now on legislation in order to modify the Judiciary Act of 1869. They want to pack the court. They think this is the only way they're going to get their agenda through. The vote in the Senate was 52-48. It was largely party line vote. Almost all of the Republicans voted for Barrett, except for Susan Collins. She's in a tough re-election battle in Maine. And all of the Democrats voted no. So that's how the vote went. And Democrats have already threatened, quote, everything is on the table. Quote, we have to first win the majority because if we don't win the majority, these questions are all moot. But if we win the majority, everything is on the table. And then Massachusetts Senator Ed Markey, who recently fended off a tough primary challenge with strong progressive backing, came out of the gates on Saturday calling for Democrats to use the threat of such radical action as a deterrent against Republicans' Supreme Court plans. Quote, Mitch McConnell won't back down, and neither will we. We can defeat him if we mobilize and organize, Markey tweeted. That is why we must make it absolutely clear that if McConnell attempts to fill this seat, we will abolish the filibuster and expand the court when we retake the Senate. So I think that's clear as day. Chuck Schumer saying everything is on the table, and Ed Markey saying that they'll abolish the filibuster and pack the Supreme Court if Joe Biden wins the election. So it's a real threat. The American people have to take this threat very, very seriously. Here, Democrats are talking, again, about amending the Judiciary Act of 1869. That's what set the number of justices to 9. And without the filibuster, Republicans, even if they keep more than 40 senators, should they lose the election and they lose some seats and Democrats regain a majority, they won't be able to block the legislation to pack the court or to do anything else. The Democrats, they want to make Washington, D.C. a state. They want to make Puerto Rico a state. So they want to pack the court. They want to pack the Senate. And they want to jam through their agenda and make it Democratic one-party rule. And I think that's a real threat right now as well. And Joe Biden, he refuses to answer this question to the American people, despite being repeatedly asked about whether he's going to pack the Supreme Court. On October 10th, Ruth DiMattei of KTNV, he asked Biden about this and court packing. I want you to take a listen to what Joe Biden had to say.
Sir, I've got to ask you about packing the courts. And I know that You said yesterday you aren't going to answer the question until after the election. But this is the number one thing that I've been asked about from viewers in the past couple of days.
Well, you've been asked by the viewers who are probably Republicans who don't want me continuing to talk about what they're doing to the court right now.
Well, sir, don't the voters deserve to know
No,
where
they
he
don't.
stands?
There you go. He doesn't think that they deserve to know, the voters, about where he stands on this. And this was just a couple of days after in Phoenix, he was asked a similar question. And here, listen to what he had to say there.
Know my opinion on court packing when the election is over. Now look, I know it's a great question, and I don't blame you for asking it. But you know, the moment I answer that question, the headline in every one of your papers will be about that. Other than focusing on what's happening now.
So there you go. He says, oh, that's going to make the headlines. And well, and tell you what, I write a few headlines. He's making the headlines by refusing to answer this question. And the American people do deserve to know who they're voting for and where they stand on some of the most important issues facing the nation. And abolishing the filibuster on legislation and court packing and amending the Judiciary Act of 1869, that's very serious business. And the American people have a right to know where Joe Biden stands on those issues. And I, for the life of me, can't figure out why he wouldn't just say, no, we're going to keep the filibuster and we're going to leave the court where it is. That's where it belongs. And that would, I believe, assuage a lot of the fears that the American people have right now about this issue. And so we have to, I guess, vote for Joe Biden in order to find out what's in his administration. Usually when Democrats win, they also sweep the House and the Senate. This is also something voters should keep in mind. Every Democratic president entering their first term, when they win the election, they also win the House and the Senate. And so if Biden wins, there won't be much the American people can do about his plans to pack the Supreme Court and to abolish the filibuster. The Constitution, all it says in Article 2, Section 2, is that the president will have the power to appoint, and by and with the advice and consent of the Senate, judges of the Supreme Court. And that's pretty much that's the only limit there. Nothing, however, sets the number of justices in stone. In order to do that, you would need a new constitutional amendment that Senator Ted Cruz is proposing that would fix the number of justices. And this is a joint resolution. Mr. Cruz introduced the following joint resolution, and it states, quote, "The Supreme Court shall be composed of 9 justices," and that's all the amendment would say in and of itself. And there's also nothing in the Constitution that is said about the Senate filibuster, except for Article 1, Section 5. And I think that this is an important thing that the American people should keep in mind as well. Each house may determine the rules of its proceedings, and that's it. That's all it says about the rules and the filibuster. Each house may determine the rules of its proceedings. So if the Senate decides to go with the nuclear option, they did it on nominations except for the Supreme Court, so that was executive appointments and judicial appointments, except for the Supreme Court in 2013. And then in 2017, when Republicans took control, they said, okay, we're just going to do 51 votes for everything, including Supreme Court justices. And that was that. That was the end of the filibuster on appointments to the executive branch and the judicial branch. And the same thing could happen on filibusters for legislation. And there's really nothing to stop it. And now with Barrett safely and easily confirmed, I might add, the issue will be forced, especially if Joe Biden wins the election. In the meantime, I think Justice Barrett's confirmation is a significant milestone for Senate Republicans, including Mitch McConnell, Senate Majority Leader, and Senate Judiciary Committee Chairman Lindsey Graham, who's also in a tough re-election battle right now. And they can return to their states. McConnell's in a re-election battle as well, and they can return to their states, making the case to their voters that they delivered a solid constitutionalist majority for the court. And that's what they promised to do, and they kept their promises. Barrett, she previously served on the 7th Circuit Court of Appeals, and she clerked again for Antonin Scalia, and she shares his textualist philosophy, which is the philosophy I favor in interpreting the law. And she wrote an interesting paper in 2017 countering the majoritarian difficulty. And she was reviewing Randy Barnett's Our Republican Constitution. And she says that an originalist interpretation allows for fidelity to the original public meaning. Quote, "The measure of a court, then, is its fidelity to the original public meaning, which serves as a constraint upon judicial decision-making. A faithful judge resists the temptation to conflate the meaning of the Constitution with the judge's own personal preference. Judges who give in to that temptation exceed the limits of their power by holding a statute unconstitutional when it is not." But she doesn't think that the basis for originalism or the original meaning is because of judicial restraint per se. It's because under Article 6 of the Constitution, it is the supreme law of the land. Quote, "The Constitution's original public meaning is important not because adhering to its limits judicial discretion, but because it is the law. And because it is the law, judges must be faithful to it." And so I think that's why President Trump nominated Barrett, and that's to ensure that the Supreme Court's commitment to safeguard the Constitution and the Bill of Rights. And that's exactly what the American people expect. In Marbury v. Madison in 1803, Justice Marshall stated that the court's role was to, quote, say what the law is. And that's what Amy Coney Barrett's going to do. And I think that's what the Supreme Court's going to do now with its new constitutionalist majority there. Barrett writes, quote, at the same time, fidelity will inevitably require a court to hold some statutes unconstitutional. When a statute conflicts with the Constitution, the fundamental law of the Constitution must take precedence, and the ordinary law of the statute must give way, because properly understood, it is not the law at all. A court does not overstep simply by holding a statute unconstitutional. It oversteps if it does so without constitutional warrant. And I wanted to show you the swearing-in ceremony of Amy Coney Barrett and some of her remarks that followed that. Take a listen to this.
I do solemnly swear
I, Amy Coney Barrett, do solemnly swear
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance to the same,
that I will bear true faith and allegiance to the same,
that I take this obligation freely,
that I take this obligation freely,
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully discharge
and that I will well and faithfully discharge
the duties of the office on which I'm about to enter.
the duties of the office on which I am about to enter.
So help me God.
So help me God.
And congratulations to Justice Amy Coney Barrett now. And here were her remarks that followed her swearing in.
The confirmation process has made ever clearer to me one of the fundamental differences between the federal judiciary and the United States Senate. And perhaps the most acute is the role of policy preferences. It is the job of a senator to pursue her policy preferences. In fact, it would be a dereliction of duty for her to put policy goals aside. By contrast, it is the job of a judge to resist her policy preferences. It would be a dereliction of duty for her to give in to them. Federal judges don't stand for election. Thus, they have no basis for claiming that their preferences reflect those of the people. This separation of duty from political preference is what makes the judiciary distinct among the three branches of government. A judge declares independence not only from Congress and the president, but also from the private beliefs that might otherwise move her. The judicial oath captures the essence of the judicial duty. The rule of law must always control. My fellow Americans, even though we judges don't face elections, we still work for you. It is your Constitution that establishes the rule of law and the judicial independence that is so central to it. The oath that I have solemnly taken tonight means at its core that I will do my job without any fear or favor, and that I will do so independently of both the political branches and of my own preferences. I love the Constitution and the democratic republic that it establishes, and I will devote myself to preserving it. Thank you.
And so those were Justice Amy Coney Barrett's comments following her swearing in, and I think, very eloquently puts forward the case that a judge's role is to say what the law is, again, in the words of Marbury v. Madison. And I'll leave you with the close here. Fundamentally, upholding the supreme law of the land is the rule of law, and there is no limited government without the Constitution. Without the Constitution and good justices, the federal government could quickly devolve into arbitrary and tyrannical rule. To prevent that from happening, the Keep 9 Amendment would help a lot in the long term. But in the short term, it appears the only way to keep the Supreme Court to 9 justices would be if the American people reelected President Donald Trump in 2020. Stay tuned. That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government. DailyTorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.